I want to tell you that the International Association of Interthermal Lawyers has published its yearly book on the streaming revolution in the music industry, which you can find outside from here. And the book will be presented this afternoon in this place at 2:30 by our president, Jeff Liebenson, and Marcelo Goyanes, who have edited the books with all the authors. Second announcement is that if anybody needs to sign for continual education credits, you can find the signing sheets outside the room. So just if you didn't do it before, just do it as long as you're leaving the room. Synchronization deals we're talking about today. We decided this year to dedicate the masterclass to this issue. Why? First of all, because it's a worthy, important, significant issue, both on economic point of view for exploitation of music and with regard to raising the awareness and notoriety of artists. Also on the legal side, it has very tricky and problematic issues to be solved. What we're talking about when we talk about synchronization, we are talking about to matching, combine two things together, two devices, two activities, two processes. And in the music industry, it's typically referred to combining and putting in time relation music with images. Images that could be still or animated, or even broader meanings. We had in 2008 a judgment of the USA Court of Appeal who stated that it's required a synchronization license to play music combined in time relation with the lyrics, with the display of the lyrics in a karaoke program. So synchronization licenses have a very broad meaning. And the problem on a strictly legal point of view is that we do not have usually in statutes or European directive a proper definition of synchronization rights. Synchronization rights are made of different kinds of rights altogether. It's a reproduction right, you need a touch of publication rights, sometimes adaptation rights as well, because sometimes you need to adaptate the music to the images you're combining them together. So it takes a very, very big attention to negotiate properly these rights. Very often are involved also moral rights in synchronization deals. So in order to talk properly of these issues, we have together a proper panel. I introduced you before Annabelle Goberti, who is a lawyer, founder of Crefovi law firm, which operates both in Paris and in London. She assists the creative industry, so composer, publishers, labels in record deals, publishing deals, but also merchandising and branding deals. On my right, there is Tom Foster, who is the head of Universal Music Publishing UK Synchronization Division, but he's also a musician, and he had experiences in deals with synchronization deals with his own music in TV commercials and show US TV shows. So he's the proper person to talk about this issue. And on my left, there is Bernard Resnick. He's a lawyer with more than 25 years of experience in the entertainment industry. He assists lots of artists and publishing houses. But I want also to remind that he's an associated professor of law at the Southwestern and Villanova Law Schools. And he plays also bass in classical orchestras. So he knows very in deep this kind of issues. We thought that our session could work better if we address three kinds of issues of synchronization rights. So Bernie, we start talking about the synchronization deals, how they work on a strictly legal technical point of view. Then Tom will give us an example, a case study on a real business case or a synchronization deal. And at the end, dulcis in fundo, as we say, Annabelle, she will show us and explain us some case law that involves also counterfeiting and some sound-alike cases where copyright infringement has been put into attention. So I leave the floor to Bernie for the first part of the presentation.
Thanks, Massimo. Ready? Thanks, Massimo. Everybody, welcome. Thanks for coming out. I have some pictures I can show you about what we're doing. It's an honor to be here once again with such an esteemed panel. At our office in Philadelphia in the USA, my wife-in-law associate, Sally, who's in the lovely pretty dress here, and we do about 100 or so of these deals every year. So we have a lot of experience in film, television, video game, advertising. Today, the primary focus will be Tom giving you a case study on advertising. But synchronization can be used in many, many ways. So what is a synchronization deal? Well, it's when you take a musical composition and you put it into an audiovisual presentation and you synchronize them so they run together. By the way, if anybody wants the slides afterwards, just write down on your business card, please send me the slides, give me the card, and I'll be happy to email them to you. But examples, as I said, films, television, video games, etc. Who are the players? There's lots and lots of people involved with a synchronization deal. It's quite complex because you have several different copyrights involved here and several different sources for all the music. So you've got a music publisher and a record company. They could be involved delivering the rights to the music. You might have a music production library that's making music specifically for use in these types of situations. Very important party here is the advertising agency and the music supervisor. They're the people, they're the creative folks who are deciding what type of music we need, what will help the picture, what will make it a better film or more effective advertisement. Occasionally you have lawyers involved. With all these different rights holders, you often have lots of lawyers involved. But in the middle, the songwriter and the recording artist who create the music. Without them, there'd be no synchronization. So it's crucial to have all these people involved. And these deals are not easy to do. Sometimes we have to do them in an hour when the television program is going on and we get a call saying we need it tonight. Other times it could take weeks. I'm working on a deal now to put some music into the end title credits of the new Terminator film. That's been going on for many, many weeks now. It's very complicated with rights holders from all over the world and multiple uses within. So we have to have two contracts here to make a synchronization license. We need a contract for the master recording, and we need a contract for the music publishing right. The master recording is called a master use license, and customarily that's owned by the record company. Sometimes if it's an individual artist, an independent artist, that person, she may own both the publishing right and the master right. We also need the synchronization license, and that's granted by the songwriter or the music publisher that represents that songwriter. Remember that we have two separate copyrights that are peacefully coexisting here, the songwriter and the recording, and we need both licenses in order to make a sync deal happen. Now, when the lawyers get together and start talking about these deals, what do we talk about? The next few minutes I'll talk about exactly what points we generally negotiate here. So first we have to define the selection. Are we using the whole thing, just a portion of it, the original, or a re-record? All those are issues depending on, will have an effect on who exactly is going to be the person that grants the license. Also, is it a worldwide license? Is it just a North American license? Is it only for a particular nation? You have to define the territory. And in today's world, the territory is almost always universal. Tom will tell us more about that. How long are we going to do this? In the advertising world, we can go as short as a few weeks. I did a deal a few months ago for just the advertising in advance of a major golf tournament. So the term was just a few days because the music was used in the ads for just a few days before the network displayed the golf tournament, and that was it. Other times it can be perpetual for length of copyright. How long it lasts can be very important. In advertising, it tends to be quarter of a year up to 2 years is the general period of time you're working with. But for films, which we know can last for decades, you need a perpetual license for length of copyright. Will it be exclusive or non-exclusive? It's very important to discuss. All I can say is that if you're going to make your deal exclusive, make sure you calculate your fee properly, because you need to get enough today to make it worth your while, possibly many, many, many years from now. I won't go through all these in great detail. You can read them yourself, but the usage and the grant of rights, exactly how will we be using this music, is very, very critical to setting the price. And the more use and the more detailed use and the more intimate the use often will raise the price higher and higher. Will it be used in a featured performance or just in the background? Will we hear the vocals or not hear the vocals? Will it be used once, twice, 3 times in the film over the credits? If it's a movie, credits are very important, and putting the music on the credit roll is a very important position to be in when you're licensing. Will it be used in advertising or trailers for the picture, or just within the body of the film itself? Remember that when it comes to major motion pictures, there are different budgets that the motion picture production companies, distributors have for the production of the film compared with the advertising and promotion of the film. So we've had situations where the production budget is exhausted, and then they come to our client saying, we'd like to use your music to promote the film. And we have a different department, a different budget, the promotion budget, and often you can get more money to be in the trailer or the advertising for the film than actually to be in the film itself. How do we figure out how much we're going to charge? There can be many, many different ways you can do this. Generally speaking, it's a flat fee, and negotiate one price to be used for the film. However, there are times when a film starts as an independent film. It might go to film festivals first, look for financing and distribution and sale by territory. In those situations, it might make sense to do what we call a step deal, which is increasing payments for increasing rights and expansion of rights over the years. We might also do a free deal, where we're just going to give you the music to get the artist or the record label or the publishing company's music known to the world. Then we could do something like a trade deal. How could you trade? Well, for example, our film has no money to license your music, but we have footage. So maybe our director can edit together a special music video for you using some of the footage from our film, and we'll trade that to you in exchange for use of the music. So there are many different ways that you can put these deals together. Who gets credit? Usually in advertising, there's not much in the way of credit, nor is there credit, generally speaking, except the very end in a television program, which goes by very quickly. But credit is very important. So arranging for negotiation of what credit you're going to get and how it will look and whether it's bigger or smaller than everyone else's credit is quite important. You're only as hot as your most recent hit in our business, so making sure you get that credit at the end of the film is quite important if you can get it. Our streaming rights included. That's the subject of this afternoon's discussion. The new book that IAEL is putting out is all about streaming. And as we all know, Netflix and other services stream entire films, stream television programming. There's video on demand. So streaming rights are definitely a part of the equation that you have to talk about when you're negotiating these deals. And then we have situations like, what if there's a breach of contract? Are we going to go to court or private arbitration? What remedies do we have? Can we stop the film from being distributed? Or can we only seek money in court in damages? And since these are international businesses now, with streaming rates going all over the internet and all over the world, if there's a dispute, where are we going to fight it out? Are we going to the home nation where the production company is? Or are we going to the nation where the music is generated? Or what about this Terminator deal I'm doing now, where we have a Chinese artist collaborating with an American record producer and a guest rapper to perform an American picture that will be displayed all over the world? If there's a dispute, one of the big questions is, where do we fight it out? I'll let you know when we figure that one out. If you want a copy of what one of these deals looks like. We've posted one for free at the IAEO website. This is the address. What I put up there for you is a combined master and synchronization deal. It's in one contract. Customarily, if there are separate owners of the separate contracts, separate copyrights, you'd have separate contracts. One would be a master license, the other is a synchronization license. The one I've posted for you is a combined, which we would use when the owner of the master recording is an independent artist that also owns their own publishing. But if you want one, just go. It's a free download. It's no problem. You can have it. And again, come see me if you have any desire for the slides and any questions. We'll be around. So thank you for listening.
Thank you very much, Bernie. I think we will have some minutes at the very end of the three presentations to get questions from the audience. I would like just to underline that you can understand how it can be complex to negotiate a synchronization license. That's the reason why some so-called music production libraries are emerging in the last years, where you combine both master license and the synchronization license from the publisher. So you have just one subject to ask and to deal with in order to clear your rights and to use the music.
Yeah, in America we call that one-stop shopping.
Mm-hmm. Yeah, that's it. Tom, I leave the floor to your presentation and your case.
Perfect.
Thank you.
Hi everybody, my name is Tom Foster. I'm the head of synchronization for Universal Music Publishing based in London. My team and I are responsible for securing sync placements across our roster of writers and artists. We look after everyone from Coldplay, Adele, Mumford & Sons, to some iconic catalogues like The Clash, New Order, and Irving Berlin. We're very big. We have a lot of music. So for my presentation, I'm going to take you through a case study of a sync deal I worked on with John Lewis back in 2013. For those of you who don't know, John Lewis are a high-end UK retailer selling everything from toasters to luxury goods. They have a very strong brand identity, and one of the characteristics they take great pride in is their British identity. So if you set aside excessive drinking and fighting at football matches, a lot of their marketing material plays on their kind of British values, fairness, reliability, so on and so forth. They're also famous for creating outstanding Christmas advertising campaigns. In the UK, these campaigns tend to be greeted with more or less the same kind of leaks, wild rumours, and anticipation as a new season of Game of Thrones. Before I go into any more detail, I thought we'd just show the commercial. Can we be able to play? Yeah.
I knew the pathway like the back of my hand. I felt the earth beneath my feet. Sat by the river and it made me complete. Oh, simple thing, where have you gone? I'm getting tired and I need someone to rely on. An empty land. I came across a fallen tree. I felt the branches of it looking at me. Is this the place we used to love? Is this the place that I've been dreaming of? Oh, simple thing, where have you gone? I'm getting tired and I need someone to rely on. And if you have a minute, why don't we go talk about it somewhere only we know?
Are we all crying yet? Or so that commercial, it cost £1 million to make that ad. All the animation was done entirely by hand, no CGI. As you'll have seen, the story in the ad is told through the music. There's no voiceover at any point. At no stage are they pushing any kind of product. Now, as a sync guy, the holy grail for me is always when you get a visual where the narrative is driven by the music, because that's when people really connect with a song. So let's talk about the creative process. The first step here was we had to find a well-known song, something recognizable, something that fits certain lyrical themes. Things like love, friendship, togetherness, going on a journey. In addition, to fit with the identity, the songwriter, of course, needed to be British. If you look at examples of John Lewis Christmas campaigns in the past, they've used songs by the Beatles, Elton John, John Lennon, and even the Smiths. Now, these are some hugely iconic British song catalogues, and I'm sure some of you may be surprised that they're even available for commercials. However, I think these writers or their representatives in each case appreciated the undeniable quality of the creative behind these ads. So in this case, the brand picked a beautiful song called Somewhere Only We Know by an English band called Keane. The meaning of the song is quite open to interpretation, but it could be about going on a journey or to a specific geographical place or a feeling or even a memory. In any case, the story of our friend the bear and the hare there was, I'm sure you'll agree, narrated absolutely perfectly by the piece of music. So why did they choose Lily to cover that song? It's Lily Allen's cover of that song, by the way. Well, in previous years, they've used artists like Ellie Goulding, Gabrielle Aplin, and most recently, Tom Odell. The idea to get Lily to record that particular piece of music was actually cooked up here in Cannes a few years ago. I was at the Lions Advertising Festival, and I was having lunch with the music consultant who does all of John Lewis's music, and she asked whether we had an artist who had a big release coming out around about Christmas. And initially, I wasn't really sure whether Lily would be up for it. She's quite careful about endorsing products, and I don't know if any of you guys follow Lily on Twitter, but she's quite vocal. She has opinions. But anyway, I pitched the idea to her, and she was like, oh my God, I've got 2 kids, and I live in the country. I bloody love John Lewis. I'll definitely do it. She was also a big admirer of Keane and Keane's songwriting, and she absolutely loved that song. So it was a really perfect fit. I'd like to make the point that actually the best sync deals are the ones where the artist is a fan of the film or the product, or those are always the best fit. It's not just about the money. It's like, of course I shop at John Lewis. I love it. That's a really good fit for us. So onto the deal stuff. Bernard touched upon this very well earlier on, but the rights negotiation was more or less the same as any other kind of sync deal. You got the master rights and the publishing rights. In this case, the master rights were with Warner Music, and we published the song. The only difference, I guess, with this deal was the song was recorded specifically for the commercial, so there was some recording and production costs involved, but it was actually a pretty straightforward process. And actually, the nice thing about this deal was we published Keane, but we also published Lily, so it was a double whammy for us. So I can't really take full credit for the whole thing, but Lily's label Parlophone did an amazing job. They did a huge amount of work marketing the song. It got a full release. It was the first single from Lily's album, and the success was absolutely remarkable. Lily got a #1 record. She sold 400,000 copies, and the success of her version of that song actually surpassed the success of Keane's original recording. So it was an amazing success. One final thing to mention is in the time that I worked on this commercial, Lily's recording of Somewhere Only We Know has been synced to a host of other campaigns, film trailers, movies, even other adverts. So it was a real kind of bona fide hit for us, and you know, hugely successful for us, for the artist, for the song. A really nice example of a sync deal that went well. Thank you.
Thank you very much, Tom. I found this presentation very compelling and interesting, especially because it focuses on a couple of issues which are really peculiar in synchronization deals. One is the moral issues. Here you had an artist, and the agency was asking himself before going to the artist, will she desire to be associated with this kind of brand, this kind of commercial? And at the end, they found it was fine. She was happy about that. And the other issue is the double end that this kind of contracts can have. It's a win-win situation. You can get money out of it, and you can raise the awareness of the artist into the public. It's a way of launching the music in the public and becoming hit #1 in the UK, for example. Thank you, Tom. And I think we can move to the last presentation from Annabelle, which is dedicated to some case law. Please.
If anyone wants to have the slides afterwards or come to talk to me in relation to their needs, don't hesitate. So right owners, so performers and record companies on the one side for the master recording, and songwriters, composers and their publishers for the underlying musical composition are increasingly facing actually, number of unlicensed use of their music by brands and individuals. Sometimes a brand will use music in a marketing campaign that's not been properly licensed, most commonly because they've selected the music at the 11th hour and the proper consents have not been granted yet. Some other times, centralized global marketing teams or the ad agencies have put in place some multi-territorial licenses, and if the brand's local markets are not fully briefed on exact usage parameters, inadvertent breaches may occur. Some other times, certain territories are a little bit on the soft side in terms of complying with copyright law. So there's, for example, many countries in the Middle East which tend to be a bit too lenient with this. And I've heard a story of an ad agency based in a country which has little IP protection, so as I said, in the Middle East, and they were representing a local car manufacturing company, and the brief received from the brand was, well, actually, I'll come to this in a second, sorry. But basically, what the ad agencies in the Middle East are saying is, yeah, well, it's all very well, guys, that you want us to pay some fees for the licensing deals, but we don't have a budget. Advertising budgets are much tinier in the Middle East, and therefore, either you revise your fee levels or else. So that's one of the reasons as well why copyright licenses are not always cleared properly before the campaign is launched. And also with the proliferation of the internet and the fact that it's now so easy to create your own content, especially with user-generated TV and streaming sites such as YouTube, and also the likes of Final Cut to create your own commercials or your own films, there's been a large increase of unlicensed commercials and films in these streaming sites. So for an artist, it's very stressful to discover his or her music being used in this context, and especially more so if it's a fan who is letting the artist know through Twitter or other social media channels. A particular issue that has arisen in the world of sync is sound-alikes. As part of its brief, the brand says to its ad agency and or music supervisor, I want some music that sounds a bit like la la la. So then the ad agency or the music supervisor could go on music libraries such as the Orchid, Extreme, Booth Music, Q Music, etc., or on streaming websites such as Spotify and plug in some meta tags to, in the search bars to find some similar music. I actually was at a sync license seminar, event in London a few months ago, and this is how they go. You know, the brands are just saying, I want some music that sounds like that, and then they go on all these music libraries, and that's how I find some similar music. And also they could, so on this point actually, Omnicon has a new service which is called Pro Tunes, which uses an algorithm which returns a list of songs that, for example, sound like a Coldplay song. So technology is definitely backing up this sort of this rise of a sounds-alike. Moreover, the ad agencies often have several in-house music composers who would compose some music in accordance with the briefs provided by the brands. And these composers are often briefed to write something similar by the brands and the ad agencies, ending up creating some sounds-alike. The composition is then checked internally by 4 or 5 people, but very rarely is it checked by lawyers who could actually, ring the bell and say, I think there's a problem here, because that sounds very much like something, I know. And ad agencies, music supervisors and music composers do not really care whether they're going to be sued or not. And I asked them at the sync license meeting I was talking to you about in London in April, and I said, how come you're not concerned that you could be sued because you just created a sound-alike? And they said, well, in the licensing agreement that we've signed with a brand, they are wholly indemnifying us in case we get sued. So it's not our problem. So I suppose that the problem of sound-alike is more the problem of the brands and also the music industry in general. And by this, I'm referring to the Bloodline case, to which I will come back in a few seconds, because this is the tip of the iceberg. Thank you. So sound-alikes, as I was saying before, cause distress to songwriters and publishers. When a brand or agency's clearance request is priced outside available budget, the temptation is to commission something similar. Coming back to my example from the Middle East, so this important client of a local ad agency in the Middle East, one of the leading local car manufacturers, says to the creative director, I want to something that sounds like, the old Zepp track, Black Dog, I think it was called. I think it was in Led Zepp 4. So the ad agency and the creative director go in and so start to brainstorm about this, and they look at their various options. Option number 1 is to reach out to the publishers of Led Zepp and ask for a license. But the agency always thinks that this is going to, they're going to be priced out. They're not going to be able to afford it. So forget option number 1. Option number 2 is that they could use the Led Zepp track, but simply re-record it. So they would still need a sync license from the owners of Led Zepp copyrights and to sync the license in the TV commercial. Forget this one too, because they would have to pay the license fee, and they don't want to do that. So what are the 2 outstanding options left? Well, the third option would be to actually do the work and create an entirely original piece of music with a rock feel. And something that is truly an original composition and which does not infringe any rights in the original Led Zepp track. Yeah, but that sounds like a little bit of work, so let's put that one on the back burner and look at our other options. So they don't do that, they don't do option 3. So option 4 is, well, they just re-record something that sounds like the Led Zepp track, but change it a bit. The old saying, we only use a few bar and we won't be infringing. So you go to a local audio studio in the Middle East, one that doesn't mind bending the rules a bit, and then come up with something which is frankly pretty similar, uses the same boogie line from the track, but then changes the words to driving, 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 as opposed to just rolling, rolling, rolling. And then we can take it along to that advertising lawyer who we know, and he can tell us it's okay. Well, except that very often the advertising lawyer, if he or she has some sense, is going to say, no, that I can't give you the okay for that one. Yeah, very often ad agencies in certain parts of the world, I'm definitely not saying that this is the rule, but that can happen. And this is how sounds-alikes are created. So when a composer is briefed using the denied overpriced track, there is intent to infringe. And if a new composition is too similar, a musicologist might be engaged to suggest amendments to reduce the risk of a legal claim that from the music publisher of a denied overpriced track. So, as the use of sound-alikes has increased in advertising, music right holders are now taking a much more aggressive approach to enforcing their rights and monitoring what is happening on the internet and other channels. Lawyers are usually involved too. I think you can backtrack once. Sorry. No, sorry. So let's go back to the bloodline decision. That's the tip of the iceberg, as I was saying. This is the sort of case which usually would settle out of court. However, when the heirs of Marvin Gaye started making some allegations that bloodline was very similar to Got to Give It Up from Marvin Gaye, the lawyer of Pharrell Williams and Robin Thicke, called Howard King, advised their clients to take preemptive action by going to court to seek to protect the new recording of their new songs, Bloodline. The statement that Thicke, Williams and their lawyers put forward was that being reminiscent of a sound was not a breach of was not copyright infringement. It might sound like a recording of the same song, but the extent to which the song is similar and open to an actionable claim is a question of objective facts. There needs to be a genuine dispute as to whether the various components of a song, which may include signature phrases, hooks, beats, chords, and melodies, are similar. As Williams testified, he wanted to emulate the feel of the 70s, and he said that no one owns a genre or a groove. So as you all know, I'm sure, a jury was called to determine the intrinsic similarity of the works. The key legal issue here was, at what point does inspiration become copying? You can be inspired by existing recordings and songs and release new recordings embodying new songs inspired by the originals. And bands actually often cite their inspiration when they are being interviewed or on stage sometimes. So Oasis is famous for saying, well, we were always very much inspired by the Beatles. However, if a recording artist writes a song that is heavily influenced by another song and is materially based on that song with respect to the various components mentioned earlier, such as the arrangement, the hooks, the chords, the melodies, then it is likely to be regarded as infringing the original song. So usually when a case like this arises, you just bring in the musicologists and you ask them for a report to check factually what are the similarities between the various songs, the two songs, the allegedly infringing song and the primary original song. So, as I'm sure you all know, in March 2015, the jury ruled that Bloodlines was too similar to Got to Give It Up, and a $7.4 million verdict had to be paid by Robin Thicke, Pharrell Williams, to the Marvin Gaye estate. Since Thicke and Williams' lawyers have filed a motion for a new trial based on 3 reasons. First one was the error in the jury instructions. Second one was an improper testimony from a musicologist. And the third one, allegedly, was insufficient evidence. They say that the information was biased and not constitute a fair trial. So there will be a decision which will be published on the 29th of this month as to whether there will be a retrial. If not, they will proceed to appeal, I should think. So the judge will consider the motion. Sorry, I just said that. So reactions from the music industry is as follows. Grammy winner John Legend was concerned that the Bloodline verdict could be a worrying precedent for artists creating music inspired by others. He told the Associated Press that, yes, he did have the feeling first time he heard Bloodlines that this was reminiscent of Got to Give It Up, but then he did not agree with the decision made by the jury that on the face of it, I mean, on a factual basis, when
À tous les amoureux de la musique, nous vous attendons nombreux sur l'esplanade Antiero. Concert gratuit de 13h à 15h en plein air, face à la mer. Venez nous y retrouver pour un déjeuner en musique. C'est à gauche, en sortant du palais. Merci. Music lovers, have some live music
I think I might
with
do
your
a little
lunch.
bit.
Head to the Pantiero, turn left when leaving the Palais main entrance. To see the stars of MIDEM Artist Accelerator in concert. Thank you.
As I was saying, John Legend thought that that although it was reminiscent, he did not agree with the jury that on the face of it, the Bloodline song was an infringement. And Howard King, the lawyer of Fick and Williams, also was quoted by the press saying, we owe it to songwriters around the world to make sure that this verdict does not stand, as it sets a horrible precedent for music and creativity going forward. All right, so taking a step back, it's of course this Bloodlines case is not the first sound-alikes infringement case that goes to court. The precedent that actually set this whole case law about sound-alike being infringements is the My Sweet Lord case in relation to George Harrison, one of the Beatles, one of the ex-Beatles, being sued in the 70s by Ronnie Mack and his a girl group called the Chiffons. So the story is that Ronnie Mack created a song in 1963, which was a hit called Ease So Fine. And Mack and the Chiffons actually sued Harrison because they really thought that My Sweet Lord was too similar. And the judge decided that although Harrison had not done it on purpose, there was some subconscious plagiarism. I thought this expression is wonderful. Subconscious plagiarism, and that the two songs were just too similar on the face of it. After the analysis done by all the musicologists, etc., that I was mentioning before, so he had to pay $587,000 at the time. So I suppose quite a lot of money to Ronnie Mack, and there are some other cases which are ongoing. So, for example, Sigur Rós, the famous band from Iceland, I think, they have actually put on their website, sigurros.co.uk, if you want to check it, the YouTube, a list of all the YouTube published ads that actually use, without their permission, Sigur Rós music into the ads. And I must point out that a lot of the ads are actually Spanish. This list runs in the dozens of ads which have not cleared the rights with Sigur Rós earlier. So another interesting case, very briefly, is about the National Party of New Zealand, which was sued by the publishers of Eminem because of its use in political campaign of the song Lose Yourself. So the defense strategy of this National Party was to say, but I actually did buy a license from Beatbox, a music supplier based in Australia and Singapore. And a music lawyer who was commenting on the case was saying that probably when the decision is published by the court, the National Party will be... Just 1 minute. Okay, fine. So, Okay, so if we don't have a lot of time, I just would like to give some advice, if that's okay. So perhaps can we, yes. What to do if your music is being infringed by a third party? If you are the owner of a copyright in the musical work, the response to copyright infringement is straightforward. You instruct your lawyer to draft a cease and desist letter, a letter before court action, setting out factually why you think there's been an infringement of your music. And of course you send it out to the alleged infringers. If there is no response to your cease and desist, or if the infringers are just denying the fact that they infringed your music, then I'm afraid the next step would actually be to go to court. If on the other hand, there is a much more professional response from the infringers, and they are ready to negotiate, then all the right owners of a copyright need to think what to ask the infringers to do. I mean, can they consider granting them a license, or if so, how much would the license be? Because there's usually a penalty fee to pay if you have not first cleared the music. So you need to devise a strategy with your lawyer and all the owners of a copyright as to exactly what it is you want to ask the infringers in the settlement. And from the perspective of the brand, I guess that the advice is, before your ad goes on air, on TV or on the internet, you need to have it checked by your lawyer. Because if you start treading on the toes of the Rolling Stones or Led Zeppelin, their publishers are going to go after you, and it's going to be very, very costly. Thank you. Sorry, I was a bit long.
Right. So, thank you very much, Annabelle. I'm sorry, but we unluckily ran out of time. So, Annabelle showed you what may happen if you do not want to engage into a synchronization agreement. So it could be a problem. Thank you very much for the presentation to our three panelists. If we just have a couple of minutes, spare minutes, if there are some questions from the audience, we would be happy to take them. Yes. Okay. Yes, please.
Did you know going into that brief that the creative process was going to be... okay, Tom. Did you know that the creative process was going to be to find a song and then have somebody else cover it? Or were you just considering everything and stumbled upon that option?
I mean, it's always kind of shrouded in secrecy, whatever John Lewis are doing with their ads every year. I mean, I'm in quite a privileged position in that I know the music consultant quite well, and you know, she never told me, she never disclosed what the ad was going to be, but she was like, you know, it's a story about these two characters, and they have this friendship, and they go on this journey together, and that's kind of enough to go on. You know, it's got to be a British song, it's got to be well known, you know, previously kind of unused, you know, like something that's kind of fresh, and that was pretty much enough to go on. Yeah, I didn't know there was going to be this story of the bear and the hare and going on this journey, but you can kind of get an idea in your head of what it might look like.
Any other? Yes, please.
This is about being the small publishers having a problem with a big artist. Sometimes we get briefs, we can send in songs for a big artist. Actually, a lot of times they already have decided who to make the songs, but they still want to have ideas. And then we send it in, and suddenly we discover that a big artist with a lot of money behind, a lot of lawyers behind, has made like a totally copy of the whole melody line in the verses, is released. And then you have this small company who don't have the big lawyers, who don't have the big money. How can they fight against this big company?
Well, was that music put on the internet afterwards? That ad, was it streamed online?
Oh, this is actually a song that is sent from us to a big company who was released by the artist Pink, and the whole melody line was our melody line.
No, my question was, sorry, this final product, was it online? Was it put online? Was it put on the internet? Or was it broadcasted all over the world?
It was released on...
Okay,
yeah.
everywhere, fine. So I don't know in which country you are based, but it means that you can basically sue them everywhere. And if I was in your shoes, I would be like this, and I would be like, this is the moment where we're going to monetize our rights, and we're going to make a lot of money out of this. And I would definitely not let go. And I would pick up my forum, yeah, where I want to sue. I would select the forum, the jurisdiction, which is the most protective to right owners. So probably France or some place like this, because it's really protective to right owners. And I would go for it. I would go for a jugular. And of course, not you, but you and your lawyer. And you can have a very, very sweet settlement at the end of it. Do you want my card?
You need to hire a
Yes, I want your card.
I can't comment. Pink's my cousin, so I can't comment.
Really?
Okay, more questions? That's fine. So thank you very much for your attendance, and thanks to the panelists. And see you in 1 hour for the book session, this place. Thank you.